Two men are charged with first-degree murder. Now, one of those two men maintains that he participated in the robbery but did not commit the actual killing. Both go to trial, both lose, and both get sentenced to the death penalty. Now, on appeal, we learn that the prosecution failed to provide exculpatory information. Namely, they did not tell the defense that the second person had already confessed to the murder. Now, you might recognize this case as Brady versus Maryland, one of the most important criminal law decisions. You're now watching the 8th part in my 10-part series where I discuss 10 of the most landmark Supreme Court decisions in criminal law and the misconceptions and misunderstandings surrounding them. Welcome back to the Law Stash channel. If you're new here, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to shop.lawstash.com and check out some of the merch, including these Do Not Arrest This Person t-shirts, hats, stickers, pins, and other items. And because you're watching this series, consider typing in the promo code 10cases to receive 10% off. Thanks for watching, and let's move on and talk about Brady versus Maryland.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
In 1958, two men, John Brady and Charles Boblet, were charged with first-degree murder in Maryland. Now, both of the men admitted to the robbery, but blamed each other in terms of actually committing the killing. Now, prior to trial, Mr. Brady's attorney requests from the prosecution all the material statements that the co-defendant, Mr. Boblet, made to the police. The prosecution provides most of the statements, but withholds one of them, the most important one, where the co-defendant, Mr. Boblet, had already confessed to the murder. The case proceeds to trial, both men lose, both get convicted, sentenced to the death penalty. Mr. Brady appeals, and on appeal it is revealed the fact that the prosecution withheld important information, namely that the co-defendant had already confessed to the murder. The case goes all the way up to the Supreme Court, where it is held that when the prosecution withholds favorable information of the accused and information that is material to the guilt or punishment, that is a violation of due process. In plain language, it means that the prosecution cannot hide evidence. So this is Brady versus Maryland, one of the most important Supreme Court decisions in criminal law. Now let's talk about some of the biggest misconceptions surrounding this case. Misconception number 1. Brady requires the prosecution to share all evidence with the defense. That is not true. The prosecution does not necessarily have to provide all the information, but they have to provide all the material information. One that's favorable to the accused and one that is material to the punishment or the guilt of the accused. So the question here, of course, is always whether the information is material, meaning that some of the statements by the witnesses, some of the notes that the police takes on the side note, is not necessarily something that the defense needs to see if it's not material to the case. Misconception number 2. The prosecutor must intend to hide evidence for Brady violation to occur. That is not true. Brady violation can occur even if the prosecutor is acting in good faith. It is not the motive of the prosecution that's important. It is the effect. If the information is hidden or withheld, that is the violation. Misconception number 3. Only the trial prosecutor is responsible for Brady disclosures. That is not true. The prosecutor on the case has a duty to learn about all the information relevant to the case, and the whole prosecutor's team is responsible, meaning all the police officers, any of the agencies that work with the prosecutor, expert witnesses, and really anybody on the case. So the Brady violation can occur even if it's the police that doesn't provide the information to the prosecutor and then the prosecutor doesn't push it forward to the defense. The prosecutor has the duty to learn about all the information relevant to the case. Misconception number 4. Brady evidence can be disclosed at any time before trial. That is not true. The information has to be provided to the defense well ahead of trial so the defense can do their own research and try to prepare to the trial. Otherwise, it's not needed. If the prosecutor provides the information on the last day of trial or the day before trial, it is not helpful to the defense because, of course, it takes weeks, if not months, to prepare for trial. Misconception number 5. All Brady violations result in an automatic reversal. That is not true. We always have to look at whether the information was material. Again, if it is not material information, then the case will not be dismissed. And even on appeal, we always have to look back whether the information was favorable enough to change the outcome of the case. And so the information might have not been material if it would not change the outcome. Misconception number 6. Brady only applies to guilt phase evidence. Not true. As I've stated before, it is also relevant to the punishment. So if the prosecutor has information that mitigates some of the facts, so it doesn't outright says the person is innocent of the crime, but mitigates the role, for example, that is material information, and the prosecution has to provide it to the defense. Misconception number 7. Brady is self-enforcing. Well, there is no formal enforcement in terms of Brady. Brady violations sometimes come to light years after the case, on appeal, on post-conviction. It takes years to figure this out. And sometimes it even takes whistleblowers to find out that there was a Brady violation. I hope you now understand a little bit more about Brady versus Maryland and how the prosecution has to provide all the evidence, or most of the evidence, to the defense, or what's even more important, not to hide information from the defense. I hope you've learned something today. I hope you enjoyed this video, and if you did, give it a thumbs up. If you're new to the Lost Stash channel, hit the subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to shop.loststash.com and check out some of the merch, including these Do Not Arrest This Person t-shirts, hats, stickers, pins, and other items. Because you're watching this particular series, type in 10 cases and you will receive 10% off. Thanks for watching, and I will see you next week for the 9th part in this 10-part series where I discuss 10 of the most important Supreme Court decisions in criminal law. Thanks for watching.